Good evening. Welcome back to yet another edition on the same day, but dateline 24th June for news of the day. Start off with acknowledgements to Mani Sahid for helping me out in reaching out to you. Government Reddy Rajgopal Reddy, MLA sitting from Congress, would file a quash proceedings challenging a criminal case started and filed against him for a meeting that was held in July 2021 when he was an MLA and a minister was participating in the said meeting. It is alleged that he pulled off the mic and created a ruckus at the meeting, leading to damage of certain properties. His counsel would argue that the minister against whom he participated in the meeting was not a public servant. B, he would argue that he had only carried out his public function of having to voice a public grievance as a public representative. And 3, that there was no damage to any of the property. He would also argue that the minister was not a public servant under the IPC. When the public prosecutor pointed out to certain definitions of who a public servant is, his counsel came back to saying that if that be so, the entire case would have to be quashed on the ground that he too was a public servant and there was no proper prior sanction to prosecute him, and therefore the matter should be quashed. All these questions Justice K. Lakshman heard and reserved his verdict. Justice S. Nanda of the Telangana High Court declared that supply of electricity was a fundamental right and it was a basic right and a person could not be deprived of it except by the due process of law. She dismissed a writ petition filed by the Yarudullah Waqf, which was aggrieved by supply of power to a person who was occupying a property which they claimed to be theirs at Lakdi Ka Pool in the city of Hyderabad. The Waqf committee would contend that the occupant of the property was not paying rent, was an illegal occupant of the property. Justice Nanda referred to the law and said that this was not an issue that could be gone into a writ court, and the action of the electricity department in supplying power to the occupier of a property was in accordance with law. Justice B. Vijay Sen Reddy directed the district authorities, the district revenue authorities of Nalgonda, to dispose of within 6 weeks a grievance where the quality of water in a pond which was 150 years old was being seriously jeopardized. Bomma Peddula and 7 others, residents of around places in Nalgonda, complained that the land in question, the pond in question, was being damaged by the inflow of drainage water. They said that the water was being used for agricultural purposes and for drinking water, and the question of sending in drainage water seriously jeopardized the use of the water. They would complain that repeated representations to the revenue authorities have been in vain. Justice N.V. Shravan Kumar is hearing a writ plea filed questioning the power of the All India Central Executive Committee of the All India Scheduled Caste Scheduled Tribe Railway Employees Association to dismiss the ad hoc committee, to dismiss the zonal executive committee and have an ad hoc committee in its place. A resolution to this effect passed by the Central Committee in April came up for challenge by E. Abraham and Papa Rao, the earlier zonal managing committee president, and Papa Rao, the secretary. They said that such power in the Central Executive Committee was arbitrary, highly illegal, and was a power given without any responsibility. They would also contend that the bylaw which empowered such action was liable to be set aside. Justice Shravan Kumar has heard the matter in part and will continue hearing the matter. Justice K. Sharat interfered with an order passed by the state government with relation to the contractors who were involved or allegedly involved in the sad incident following the celebration of the state formation day at the Eragada hospital in the city. It is alleged, according to reports, that on 2nd June, the inmates were given special sweets which led to a contaminated consumption of contaminated food. One person died and multiple number of people suffered from gastroenteritis. This led to the government quashing the tenders both in favor of the supplier of food and all services global private limited, which was in charge of other facility services. All services global private limited was up again in arms against the said action, saying that they were not responsible for the tragedy and they could not have terminated their contract without a proper inquiry. However, their senior counsel said that a third party has since been appointed to run the society, and they would be more than happy if that part of the order which stalled their participation in further tenders was suspended. The judge recorded the concession and said that the order prima facie looked that it was in violation of principles of natural justice and suspended the order in part, thereby enabling all service global private limited to participate in future tenders across the board. On that count, goodbye for the day and acknowledgements to Sai. Bye-bye.